it please the court, I'm Lewis Jenkins, and I represent Mr. Wortman in this appeal. And actually, I did in the trial court too. So I've been representing Mr. Wortman in this post-conviction appeal, and I'd like to reserve 8 minutes for rebuttal, please.
So you're going to be very familiar with the record.
I was going to say, did you say 8 minutes?
I did.
Oh, you did say 8 minutes?
At first I thought he said A, and then I wasn't sure if he said 8.
That's fine. You reserve whatever you like, and you don't have to use all your time either. We just want to be clear about that.
I will, I usually think I'm not going to use all my time, Your Honor, and then I end up dancing around up here answering questions, and I expect that's going to be true here. So good afternoon. I will take up what I think is the easiest issue first, because they're really, in this post-conviction appeal, this is really about the breach of a plea agreement. And so the first thing was, and we've been here once before about this issue, Mr. Wortman filed this post-conviction petition pro se, and it was summarily dismissed. He appealed pro se to this court, and then I appeared to represent him in this court. We took on the issue of whether or not the petition adequately stated a case and whether of post-conviction or due process tolling in post-conviction. This court reversed the summary dismissal and remanded for a hearing. We had some trouble getting a hearing done, but we finally did get that done. And at that hearing, we put on evidence that we believe would have constituted grounds for due process tolling. The trial court took the matter under advisement in March of last year, and then in May of last year called us back to rule on the case. And the day the ruling came down, the trial court ruled and did not specifically include a ruling on the timing issue. And so I gently raised that issue at the end of the ruling, which is a quote from the record that I've included on page 6 of our reply brief. And the trial court then said, yes, as to the timing issue, I think the state agreed at the hearing that they weren't going to pursue that. I copied the exact wording right there into the brief, and of course the court can look at the transcript and see what it said.
I want to talk about the timeliness issue a little bit. So you had the parole hearing, and then you took an administrative appeal. You did a writ of certiorari, and the Supreme Court denied that. In the administrative appeal and the cert, were you arguing breach of contract, or were you just arguing straight up they were wrong in denying parole?
Well,
because those are two different things.
yes, sir, and I understand that. In order to be precise in my answer, I take it that you mean by you mean my client, not me, because I was not representing him in that.
Yes, your client, after his parole was denied, you're correct. After his parole was denied, there were several things that took place challenging the denial of that parole. Was it just a general challenge to the denial of parole, or was he also arguing the breach of contract as part of that denial, as part of those challenges?
He was certainly not arguing the breach of contract issue that we raised in this post-conviction
Okay,
appeal.
so then how is this timely? Because if the parole was 2019,
September 2019, Your Honor.
and you knew at that time, at that moment, your client is on notice that allegedly the state has breached this contract, but you didn't file anything for a year.
Well, so, Your Honor, I think that were we in the context of a civil case and we were dealing with the saving statute 283105, which has specific statutory terms that say if you have a dismissal that's not on the merits, then you have to refile within 1 year. Even in that context, the statute says that your 1 year starts to run after all the appeals any appeals are over in that context. But I think, in fact, he did file this
But
post-conviction.
those are different. That's why I asked the question the way I did. The administrative hearing and the cert appeals are different than a breach of contract issue. And so I get it. If those were all appeals of the breach of contract issue for whatever reason, then yes, you were diligently pursuing it and you can't file the PC until after those are done. But you have two separate claims here. And one and I keep saying you, but
It's all right.
You sat on for over a year.
Yes, sir. So I understand what you're saying, Your Honor. I respectfully say the concept of diligently pursuing your rights is not nearly that narrow. And there's no case that says it's that narrow. And
There's plenty of case law that talks about once you discover an issue, a claim, an allegation, whatever it is, you have to diligently pursue that claim. You can't just sit back and 10 years later go, oh, by the way, we learned of this 10 years ago, but now that we have no other alternatives of relief, we're now going to raise it. It is that narrow. Once you know about it, your clock starts to run for all practical purposes.
That's not what the Foley case seems to say to me, Your Honor. In the Foley case, the gentleman was pursuing two different issues. He was trying to address in that case, the issue was whether or not he had to register for the sexual offender registry. The law changed in the intervening time. He came back long after a year. I think on the facts of that case, it was about 3 years, and he challenged that appeal. I don't think that the concept of diligently trying to protect your rights is narrow enough to say if you didn't raise this specific claim, then you cannot raise it later after you're over with. The other thing is, Your Honor, I guess if you're going to put it in breach of contract terms, I mean, arguably the reasonable time period within which to bring that claim might be 6 years, which is the breach of contract statute of limitations.
That's not the issue before us, but I use the breach of contract because your entire brief is about a contract between the state and
Yes, sir.
And your client.
So that issue that you raised, Your Honor, is not the issue that the state raised. In my respectful argument, that's not the issue the state raised either. I stood right in the courtroom. I brought up the timing issue so that it would not be omitted from the decision. The trial court said, I believe that the state was not going to contest this. The state stood right there and said,
well, and that may be a better question for the Attorney General's office because they're the ones who.
But we're not bound by that.
Yeah.
We're not bound by that. And they cite case law that says the state on appeal is not bound by any concessions made by the state below. Even if we don't like that rule, that's a rule. So
I understand that, but I think you are bound by a rule of appellate procedure 36, which is that they are not permitted to raise in this court anything as an issue to which they contributed being made an error in the trial court. And I don't know that there's ever been a clearer application of Rule 36 than the trial court specifically saying, this is what I'm going to do, correct? And the state saying, thank you. So I don't think any of that case law that they cited overcomes Rule of Appellate Procedure 36.
I think you might be wrong. I think this very argument was addressed in, I can't pronounce the name of the case, but you can proceed with your argument.
It will not be the first time I've been wrong if I am wrong, Judge McMullen, but I'm going to continue to say I'm not wrong. I understand, but as a minimum, it would not be appropriate for this court to rule on that. This order would have to be vacated, and the trial court would have to make some kind of findings on that in the first instance, and then we would be back here, and the state could explain to the trial court then why it failed to do that, and the trial court could take that up. In the state's brief, they raised the issue of this timeliness, so I responded. We relied on the Foley case, and I think that the due process tolling makes it clear that all this argument about whether or not the state conceded that issue, whether or not that binds this court doesn't matter, because under the Foley decision, I think, and we made a long and I think clear argument about that case in our briefing, which we pointed out that in fact the facts of this case track that decision in Foley.
All right, so say we agree with you and it's timely. How in the world is the state in a plea negotiation bound when they say, okay, we agree at the end of the day as part of this negotiation, your client's going to get X number of years at X percent, which is all it is a release eligibility act. There's no guarantee.
We're not arguing that there is.
I know, but I'm just setting the record here. How is the state bound that by entering into that plea agreement, they can't oppose, or, I mean, if you take your argument to its extreme, not only can they not oppose, they probably can't even support. They have to remain silent. It's basically, because the contract doesn't, the contract, i.e. the plea agreement, doesn't speak to it at all. So how are they bound by that?
So I think that when you put it back in the context of good faith and fair dealing, Your Honor, that's a pretty easy question to answer, and that is this. This is not, what happened in this case is not opposing parole. What happened in this case is twice, very clearly, and maybe a third time at the hearing, but once by the letter that Ms.
Okay, but where in the plea agreement does it say they can't be obnoxiously loud or semi-opposed? Where does it say they can't oppose parole at all?
It says that in the context of the implied covenant of good faith and fair dealing, which rises to a constitutional requirement in this case, Your Honor. That is, what that case says in all of the commercial cases where that's been decided is that one party cannot attempt to deprive the other party of the benefit of the bargain.
But but the 30% is a benefit of the bargain is something you would actually be guaranteed. You're not guaranteed the 30%.
The benefit of the bargain is that each party will comply with the terms of the agreement that they made, Your Honor. In the context of this agreement, everybody understood that there was no guarantee about when that would occur. But each party had to act with good faith and fair dealing. And what they said was, we want you to plead guilty to a range 2 sentence, which would have 35% release eligibility, but we're willing to say that you are a proper person to be considered.
It's not what that says. All they're saying is it's a negotiation. We want this, you want this, how do we meet in the middle? It's not a concession by the state that you are a person who is deserving of parole at 30%. That's not at all what a plea agreement is.
And also, I did not say deserving, Your Honor. I said you're a proper person to be considered. And that is exactly what they attempted to deprive Mr. Wortman of.
But if the state only wanted him to serve 30% of his sentence, why didn't they just agree to 9 years at 100%, and then everybody would be in agreement that he gets out in 9 years?
I don't know why they didn't make that
because it's a negotiation. It's not a promise that we're not going to oppose it.
It's a promise that we are not going to deprive you of the fair consideration under this agreement, and that's exactly what they did.
You're at your time. I respectfully, I want to give Judge Dyer the opportunity to conclude his questions and you the opportunity
Yes,
to
ma'am.
answer.
That's why I reserved.
No, respectfully, if you want to conclude at this point, that's fine, but you do need to be conscious, or aware that you're at the end of your time.
I will take up any further questions in the time I saved for rebuttal. That's why I saved 8 minutes, Your Honor.
Thank you. Mr. Barker.
Afternoon, Your Honors.
Good afternoon.
Benjamin Barker on behalf of the state. Your Honors, this court should dismiss this post-conviction petition because it was untimely and petitioner did not establish that due process tolling was warranted. The post-conviction court found that the state had conceded this timeliness issue. Respectfully, I'm not sure how it arrived at that conclusion. I could find nothing in the transcript to support such a conclusion. But even if the state had conceded, like the panel seems keenly aware of, we would not be bound by such a concession at this point.
It's a jurisdictional question, correct?
It is a jurisdictional question. That's the whole point, Your Honor. And a party can't, somehow concede its way into giving a court jurisdiction it doesn't have. So I don't want to belabor that point more than I need to. Just even if the state had conceded, we could raise timeliness now.
Well, the state's concession, and then also even the trial court can't grant us jurisdiction, can they?
Exactly. It just doesn't make sense. A trial court can somehow conjure up jurisdiction that it never had to begin with.
I feel like I know your answer to my next question, but I'm going to ask it anyway.
Please.
Is the state, every time they enter into a plea agreement, saying they will never oppose parole?
Absolutely
Are
not,
they
Your Honor.
saying every time they're absolutely saying they will never?
Absolutely not.
Okay, thank
Sorry
you.
if I should have been there.
That's the-
Actually, it shocked me there for a second.
No, go ahead.
And on the flip side of that, does that mean that every time they enter into a plea agreement and they say at your red date, we will actively support your parole? And we believe
Absolutely.
you're entitled to parole or should be given
not,
parole?
Your Honor.
So what is a plea agreement then?
The plea agreement is just that. It's like you picked up on. It's just different bargaining chips that the parties use to negotiate a resolution to this case. That's exactly what happened here. The state just did not breach the plea agreement. The petitioner bargained for and received a 30-year sentence at 30% release eligibility. The state's future position at a parole hearing was never part of that agreement. And nothing in the record ever indicated that petitioner was guaranteed release after serving only 30% of his sentence. And yet, petitioner's subjective interpretation that he testified to at the hearing below, if even accurate given his legal education and background as an attorney, is completely irrelevant to objectively interpreting the terms of this plea agreement. The state agreed that petitioner would be eligible to receive a parole hearing after serving 30% of his sentence. This was not a recommendation that he actually be paroled. This court should not reward petitioner's attempts to read terms into the plea agreement that just are not there. So if,
No matter what the state agreed to or not, I mean, the parole board can do what it wants, right?
absolutely. The state, we could have said we want him released yesterday, and the parole board could still have denied parole. If this,
Right, so if the plea agreement for some reason said, after service of 35 days, the state will seek release from the parole board, I mean, that doesn't mean anything. The parole board's going to look at it and go, the Department of Corrections going to look at it and say, your red date's at 30% and 30 days ain't 30%. Doesn't matter what the state says, right?
that's right. The state, even if it had made some agreement, it would have been powerless to enforce it at the parole hearing. The best it could do is recommend to the parole board that the petitioner be paroled. Either way,
So let me ask you this. Is there any way, I recognize it's not in the paperwork, most likely, I've not seen it, but most likely it's not in the paperwork, any sort of provision like this. Is there any statement from reading the guilty plea transcript that one could at least infer that the state was saying, hey, when your 30% date comes up, we'll show up at the parole hearing and support you?
not as I recall, nothing, at least as I stand here right now, nothing from my recollection of the guilty plea hearing stands out as, it could possibly be interpreted that way. Even so, if that were his subjective interpretation, it still would not change what the plea agreement objectively is.
I think Judge Dyer's asking about like a dirty pool argument. Somehow
Yeah.
there's emails, it might not be in writing, but we have a gentleman's agreement, nothing like that.
Not that I could find, Your Honor, certainly not. If this court has no further questions, the state respectfully requests that you either dismiss the post-conviction petition on timeliness grounds, or if this court reaches a merits, should affirm the denial of relief. Thank you, Your Honors.
Thank you, Ms. Barker. Mr. Jenkins, you have your 8 minutes, sir.
So if you want to take a minute off, since I took a minute too long,
You're
I'll
fine.
Do you want to pick up with the?
Well, I do have a couple more, at least one more question.
You-
So, yeah, you shouldn't have done that. So, I mean, if I want to take your argument to the extreme, I could easily say that once the state and the defendant reached a plea agreement, had a signed plea agreement, and took it to the trial judge, and the trial judge said, I'm not accepting that. If I take your argument to the extreme, under your argument, I would be able to stand up at the sentencing hearing after that trial and say, Your Honor, the state can't ask for more than X number of years at X percent because they entered into a contract a year and a half ago with me.
No, sir. It doesn't become an enforceable contract until the plea is accepted by the court. So I don't think that from my perspective, that's not.
But I'm taking, your argument is, despite the fact that there's nothing in the document that says the state will do A or B, that they're bound by that document. Well, if you take that argument to its extreme, there's nothing in the document that says, hey, if the trial court rejects this, we're not bound by, we don't have to do anything. I could make the argument at the sentencing hearing, hey, they're bound by that agreement they made 2 years ago. And you answered my question just then by saying, no, that's not correct. That's
Yes,
not
sir.
a correct statement of the
So,
law.
I
So
think-
why is this correct then?
Excuse me for talking over you, Your Honor. I think that's what people in the criminal context miss too often about the implied duty of good faith and fair dealing. It is never in the contract in any commercial context. And I've been most familiar with it for the last 30 years in the context of commercial contracts. But I've given the court the authority to say that the implied duty of good faith and fair dealing, which by the word implied is never written down in the contract. It means that neither party will attempt to deprive the other party of the benefit of the bargain that they made.
Well,
And this letter.
But wait a second. You're applying civil contract law to a criminal case. This for starters. And second of all, cite me one case, criminal case, that supports your claim that that says the state is bound to not oppose parole if they enter into a plea agreement.
I think I said in my brief, Your Honor, that I believe this particular case presents a question of first impression, and I still believe that. But I gave the court the citations, a whole paragraph of them, where courts have ruled that the implied duty of good faith and fair dealing applies to plea agreements. That is I think that's beyond question. And what that means is that regardless of whether it's written in the contract specifically or not, neither party will attempt to deprive the other party of the benefit of the bargain. And
So-
that's,
Mr. Jenkins, I'm not a civil lawyer, and I never have been, but what you just stated, am I paraphrasing it correctly that your argument is it's against the spirit of the agreement?
well, I wouldn't use the word spirit, Your Honor, but I understand, I think, what you're trying to convey, and I understand with what you're trying to convey. In the specific context of Tennessee law, the Tennessee Supreme Court has said in every contract, regardless of whether or not it's written into the contract, there's an implied duty of good faith and fair dealing. And that means a couple of things. One, it means honesty in fact, and two, it means that neither party will take actions during the pendency of the contract to deprive the other party of the benefit of the bargain that was made.
Well, I appreciate I know it's in the record, but I appreciate the picture of part of the plea agreement. Why wasn't the language just in there that state will not oppose parole?
So I don't know why it wasn't in there. I can't answer that. I wasn't involved in it, Your Honor, but I will say it doesn't have to be. It's every contract includes it regardless
so-
of whether or not it's in.
I have one question. Listening to you answer my colleagues' questions, and you've been really good. They've been really asking you a lot of questions. And I've read your brief. I've read the state's brief. My question to you is, if I agree with you about the contract law and that application, in every felony case in the state of Tennessee, there is a red date, release eligibility. That's a part of every felony case. That'll be a part of every plea agreement, virtually. Then will we be saying as a court that the state has entered a contract with the defendant that requires the state, that binds the state to remain silent?
No, ma'am.
Okay. Explain to me why that's not the case.
Because I believe that the facts of this case are unusual enough that the rule in this case would be confined to the following rule, which is when there's a Hicks plea and the state starts out with a range that includes one release eligibility date, reduces that to the release eligibility range for another date, that the state is acknowledging that that person is a proper candidate for parole at the second release eligibility date, and it is not allowed to take actions that are purposefully designed to keep that person from being considered. And I think, given the letter and given Mr. Hagerman's testimony, that it is clear that the state was not just opposed to Mr. Wortman's parole, but the state was actively, in every way it could, saying this man should never be eligible for parole. Those are their words, not mine.
Why is what your client or a client, anybody who enters a Hicks plea, why is that bargaining and resolution any different than, hey, you're a range 2, we're going to plead you at a range 2, and now we're going to negotiate the years? Why is that any different? I mean, what you're bargaining for, I mean, you keep talking about shouldn't deprive the individual of what they bargained for, right? That's the contract law premise.
That is,
what they
yes, sir.
bargained for was this and this, years and percentage. That's what they bargained for. That's what they got. The state's not keeping them from getting that.
I think in this case, it's fair to say the state was doing everything it could to prevent Mr. Wortman from getting the benefit of his bargain by saying again.
The benefit of his
and
bargain is
again.
he got a parole hearing at that time. It's not that he gets parole.
He gets a parole hearing that the state is not actively trying to undermine, Your Honor, which is what they were doing. They were saying, never parole this person.
I go back to Judge McMullen's question then, because I don't know that if we were to agree with you that we could limit it to Hicks cases, that it would just have to be anytime anyone enters a plea with a release with a red date, that the state has to sit silently during parole. I don't know how you can make that your argument as narrow as you wanted to make.
I think I could make the argument this narrow, and I've got 8 seconds. May I answer this question,
Yes, please answer. Yes.
I think that you can resolve this case by saying this, that when the state makes this statement, but please do not treat this as a typical parolable sentence. This is a defendant who had every opportunity in life and nonetheless chose to try and kill his wife and leave his kids without a mother. When you say, we made an agreement that he should be considered for parole, we want you never to consider him for parole, that is a breach of the duty of good faith and fair dealing. Those particular facts are undisputed in this case and are the basis for a narrow decision that will prevent this rule from consuming the plea process.
All right. Thank you, counsel.
Thank you.
Appreciate both parties' arguments, and we will take the matter under advisement. Once again, thank you, gentlemen. Madam Clerk, call the next case.